In the next few minutes, you will learn the essential components covering must-have clauses that protect your cash flow, intellectual property, and reputation. You will also discover the exact way to sign as an officer so you never incur personal liability. Grasping the details of subcontractor agreements is essential for protecting yourself from costly mistakes. A well-structured agreement helps you avoid being misclassified as an employee, shields you from unexpected legal and financial liabilities, and ensures you get paid on time for your work. By understanding these contracts, you safeguard your professional reputation and financial stability. Always define the scope of work if possible, specific deliverables, acceptance criteria, and key milestones. Make sure any changes are managed through a formal change order process requiring written approval before new work begins. This approach protects both parties by preventing misunderstandings and ensuring accountability throughout the contract. Clearly outline your payment terms, your rates, invoicing frequency, and the time frame for payment. Include details about late fees, which expenses are reimbursable, how travel is handled, and how taxes will be paid. This level of detail ensures you get paid promptly and protects you from misunderstandings or disputes over money. Your contract should be clear that you are an independent contractor, not as an employee of the subcontracting firm or client. Specify that you retain control over how, when, and with what tools you complete your work where possible. This distinction helps protect your legal status and ensures you maintain autonomy in your professional relationship. Define who will own the final deliverables, whether the client receives full ownership, the consulting firm, or you retain rights and grant them a license to use your work. Make sure to reserve any pre-existing intellectual property and explicitly state your right to showcase completed projects, if possible, in your professional portfolio. Also ensure it is clear that they can only claim rights to work they have explicitly paid for during billable time. This protects your creative assets completed on your own time and ensures you maintain control over how your work is used and displayed. Want help becoming an independent contractor and setting up rock-solid agreements? Click the link in the description. We will guide you step by step. Clearly specify what information is considered confidential, how it can be used, and duration these protections apply. Include any exceptions to confidentiality and ensure the agreement covers data protection requirements if you handle personal or sensitive data. This helps safeguard both parties' interests and ensures compliance with privacy regulations. Ensure your agreement includes indemnity clauses to protect both parties from third-party claims. Limit your liability to the total fees paid under the contract and specifically exclude consequential damages. Clearly outline the insurance requirements for each party, ensuring coverage is appropriate work and potential risks. State agreement duration and outline the conditions under which either party can terminate the contract. Include provisions for winding down the project or extending it, such as notice periods for extensions, and procedures for handing over unfinished work. Specify how payment for work in progress will be handled if the contract ends early. Require agreement with written consent before you can subcontract any part of the work to others. Carefully review non-solicit clauses to confirm they are reasonable and do not unfairly restrict your ability to pursue future opportunities. These provisions protect your business interests while maintaining fair and transparent working relationships. Ensure non-compete clauses are not overly broad or restrictive. The agreement should only limit you from working with direct competitors or within a narrowly defined scope, rather than barring you from your entire industry or geographic region. This protects your ability to pursue future opportunities while maintaining fair competition. Define steps for resolving disputes, including escalation procedures, mediation, and arbitration options. Specify which governing law will apply to the agreement and the venue where any legal proceedings will take place. Ensure that both parties understand how conflicts will be managed and where they will be addressed. Always use your company's full legal name and include your official title as an officer. Avoid signing with your personal name or offering any personal guarantees, as this protects you from individual liability. This practice ensures that only your business, not you personally, is responsible for the obligations under the contract. Review frequently asked questions and pay close attention to country-specific legal requirements that may affect your subcontractor agreement. After your initial review, it's wise to have a qualified attorney examine the final draft to ensure your interests are fully protected before you sign. The larger the value of the contract, the more important this final step is. If you want to become an independent contractor, freelancer, or consultant, click on the link in the description below to learn more about our program. Thanks for watching.